This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
And on page 72 we've got the procedure for alteration. The procedure. In order that the Constitution shall be altered, it's not just a simple majority who must vote in favour. It's not just a simple majority of the votes which are cast in favour. It's a 75% majority. There shall be not less than 75% of the votes cast in favour in order to pass a special resolution. Now, the simple resolutions are called ordinary resolutions. And an ordinary resolution is just one more vote in favour than votes against. So this, therefore, is a special majority. It's a requirement of 75% voting in favour. Now, it's normally at this stage that I play a little game with a course on the basis that we are the entire membership, and what are we? We're 20 of us in the room. On the basis that we 20 are the entire membership of a company, what is the minimum number of members who must vote in favour in order to pass a special resolution? 15 is a good answer, but it's not right. It's actually just one. Those in favour, me. Those against, no one. 100% pass. You only count the votes which are actually cast. You don't count the abstentions. You don't count the people who don't vote. You only count the people who do vote. So it's a bit unfair, an idea. I'm playing a little trick on you there. So let's assume that we all, in fact, do vote. And so I'll ask the question again. In the circumstance where 20 of us are the entire membership of a company, what is the minimum number of members who must vote in favour in order that a special resolution be passed? 15? 16, no, it's not more than 75, it's 75. It's not less than 75, actually, is the wording. So presumably you're going to say 15. It's a good answer, but it's still not right. It's 1. All those in favour, me. All those against, 19 of you. Let me count the votes. 1, 2, 3, 19 votes. I've got 400 votes. I didn't say, did I, that we all have the same number of shares? So it's actually the number of shares which attract or which carry the votes. And if we don't have all the same number, we don't all have the same number of shares, it comes down to a vote count. On a show of hands, which is what the chair will ask for at the end of a debate, the chair will say, I think we've all had our say. Does anybody want to say anything more about this resolution? Okay, the debate is ended. The resolution, therefore, is, and he will read it from the agenda, the resolution is to discuss and, if thought fit, to amend the Constitution in the following way, blah, 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 blah. All those in favour, please show your hand. And this is called a show of hands. People will raise their hand and the chair will count the number of hands. But that doesn't take account of the fact that I've got 400 shares and you've only got 1 each. And therefore any member can say to the chair, Mr. Chair or Madam Chair, can we have a poll? A P-O-L-L. Can we have a poll? And a poll is a vote count. And so we have to register. How many votes do you have, Christina? How many votes have you got, Eddie? Leanna, how many votes have you got? Are you in favour or against? And we have to count the votes in order to determine whether we've reached this 75% majority. So this is a special resolution, 75% majority. A special resolution requires 14 days' notice. If the resolution, listen, if the resolution is to be proposed and voted upon at the annual general meeting, as distinct from any other general meeting, if the resolution is on the agenda for the annual general meeting, then the annual general meeting requires 21 days' notice. So the special resolution effectively gets 21 days' notice because it's on the agenda of the annual general meeting. But if it's an other general meeting, which is not an annual general meeting, there may be the need to call a meeting of members between annual general meetings. And if I call an other general meeting, that only requires 14 days' notice. So special resolution has a minimum of 14 days' notice, but it may need 21 if it's at an annual general meeting. And it's a 75%. It's members voting not less than 75. So 75 is enough. It doesn't have to be 76 or 75.1. 75 is enough. A copy of the resolution gets delivered to the registrar in Company's House in Cardiff with all the registrar staff, and copies of resolutions are coming in on a daily basis. Lots and lots of resolutions being passed by all these different companies. Big companies, little companies, community interest companies, sending in these copies of their special resolutions. And these will then be recorded and put into the company file. And when you go onto the internet and access the company file, there will be a list of special resolutions that that company has passed since history, since the start of the company. In addition, a copy of the amended articles must go to the registrar. Of course, if you're going to alter the Constitution, you should then alter the articles themselves and send an amended copy of the articles. Even though only one, in those extreme circumstances which I played the game with you, in the circumstance where only one member votes and the other 19 of you abstain, that special resolution is passed and that special resolution is binding on all of you. Even though only one person votes and they only have one vote, all the other 19 abstaining, that resolution is binding on the company and therefore on all of you. You should have voted. The articles may say that for a meeting proposing an alteration, the affected member must be present. I've already told you that. So the affected member can prevent alteration. The articles may require a greater majority than 75. They may do. It's unusual. I don't know of any circumstance where we need more than 75% to propose or pass a special resolution. But the Constitution can never be drafted in such a way that it prevents alteration ever. You cannot draft the articles. It's not right to be able to draft the articles in such a way that they cannot be altered. They must always be capable of alteration. Company names. Basic rule. Well, what about the basic rule? Remember, a company is a person, just the same as you are a person. So who chose your name? Who chose your name, Leanna? Your parents, yeah, the people who created you. So who chooses a company's name? The person who created it, the promoter. Was there any restriction on the name that they chose for you, Leanna? There wasn't. They could have called you Robert. Yes, they could. Yes, they could. They could have called you Blossom. They could have called you Oak Tree. They could have called you whatever they wanted. All right? There's no restriction on the choice of name. And you're not prevented from calling Leanna Leanna just because there happens also to be another Leanna. There may be multiple people with exactly the same name. John is a very common name in England for men. Smith is a very common surname in England. And there are many, many, many John Smiths. There's even a beer called John Smith's. There are many John Smiths in the UK. And so there's no limit on the names you can give to your children as people. But for companies, there are limits. There are restrictions. The registrar may refuse to register a company with a name which is misleading or offensive. I'm sorry. I'm sorry. What do you understand by the word misleading? It's leading, which is miss, isn't it? What is misleading? Well, in the context of company names, misleading means giving the wrong impression about the scale of operations or the resources available to the company. You can't call yourself ABC Worldwide Limited. if in fact all you're doing is trading in Minsk, because you're not worldwide. You can't call yourself ABC Electronics if all you're doing is providing tuition services. So if it's a misleading name, the registrar will probably refuse to register it. Well, the purpose of the company, it says within the Constitution what the purpose of the company is, what its objectives are, and therefore the registrar will be able to see, and the name will then be classed as possibly misleading. Well, if you do a wide name like that, then you wouldn't call yourself electronics, because it's misleading, it's confining you. Your name suggests that you're only being involved in electronics. Offensive, as some of the words I use when I'm lecturing may be deemed to be offensive. Some of the things I put on the screen, you may think, I don't think they're offensive, but you may think they're offensive. So offensive is very much a subjective matter. What's offensive in your mind may not be offensive in mine, or equally the other way around. I'm not going to inquire about your private habits, but I may not approve of them. I may find them to be offensive. Equally, you may find my private habits to be offensive. So offensive is very subjective. And of course, the registrar of companies changes. This, I think, is a woman at the moment, but when she retires or dies, then somebody else will become registrar. And offensiveness is in the mind of the registrar. So it's the registrar who will issue on a regular basis the sort of words which the registrar considers to be offensive. It's a little bit awkward because some words, for instance, in your language, may be offensive in mine, or equally some words in my language may be offensive in yours. There is a game based on dice. There's a game in England called Yahtzee. Yahtzee, which I understand is in Russian is possibly not as innocent as it's just a game called Yahtzee. I understand, I know this. We have the situation, I came here the day after George Bush arrived here. I was also coming up here. And I remember there were two signs. I caught the plane up, and there were two signs on the road leading from the airport to the city. And one of them said, "Welcome, George Bush." Which is fine, it's good, and George himself apparently was very pleased to see this. And then the next sign said, "George Bush, Peace Duke." I can see nothing wrong with that. The man is a Duke of Peace. He doesn't friendly fire. And what's the problem? You could call the you could call the Duke of Edinburgh, the Queen's husband. You could call him a Peace Duke as well. So, absolutely nothing wrong. So it may be that, for instance, Peace Duke could be offensive in somebody else's language, maybe if you pronounced it just slightly differently. And so names which are offensive, or which are brought to the registrar's attention as being offensive, then the registrar may direct that you should change your name, or may refuse to register a company with that name. Other offensive names in the world of registrars and company names, other offensive bits, and words which connect you with royalty, with the UK monarchy. So I couldn't call myself Prince Charles Accountancy Tutors, or I couldn't call myself the Queen's ACCA tutor. I can't do it because I'm associating myself with royalty. I couldn't associate myself with foreign or friendly governments. I could associate myself with, for instance, Libya, Gaddafi Accountancy Tutors, or even American Friendly Fire. I could associate myself with anyone if... I'm sorry, let me change that. I can't associate myself with a foreign and friendly government. I can't associate myself with a local council or local authority. I couldn't call myself Manchester Accountancy Tutors, because it's suggesting that I'm related in some way with the Manchester Authority. So you're not allowed to get that specific. You can say Accountants and Tutors brackets Manchester, which is a description of your location, but I can't call myself Manchester Accountants and Tutors because it suggests that I am associated with the Manchester Council. I can't use words like bank within my name, or building society, or friendly society, unless I genuinely am a bank, a building society, or a friendly society. I can't use those words because it's misleading, it's offensive. I can't use words which are the same as an already registered company. I couldn't call myself La Telecom Limited because you've already got the company here, and they would object and they'd say, no, you can't have that name because people will think that I am them, and that's not fair. I'm them beginning to trade off their goodwill. There was an auditing question, I don't know if it's still within the P7 audit revision kit. There was an audit question where there's a company called Blake 7, and one of the directors left and wanted to establish their own company, and they'd chosen the name Blake's Heaven. Now, it's completely different. Blake's 7 and Blake's Heaven, hang on a minute, Blake's 7 and Blake's Heaven, they're pretty similar, aren't they? And therefore I'm not allowed. It's too similar, and it sounds the same. So I'm not allowed to use a name which is likely to be confused with an existing company name. A name may be restricted. Those are restrictions which are applied by the Registrar of Companies, these misleading and offensive names. Name may be restricted by statute, and I already gave you on Wednesday the acronym ANZAC and the illustration of the ANZAC brackets Restriction of Trade Use of Word Act of 1916. And you do remember what the acronym ANZAC stands for because you were paying attention on Wednesday. What's ANZAC? Madeira. The NZ gives you the clue. New Zealand. So what's the A there for? The first A. It's got to be Australia. The Australia and New Zealand Army Corps, Army Body. And because of the bravery that these people showed, it will be unfair, it will be wrong, it will be immoral, unethical for me to create the ANZAC Tuition Providers Limited, because people will then associate me with all these brave Australian and New Zealand people. So some words are protected by statute. I can't use the words Red Cross or Red Crescent in my name because it's associating me with the Red Cross service, the Kruisjes Sarkans. Sarkans Kruis. Well, yeah, you know what I mean. It's a Red Cross. So I'm not allowed to use the Red Cross within my name. I'm not allowed to use, and it's an organization which I think you do have here, but it's not in any way as popular as in the UK, and that's the Boy Scouts and the Girl Guides. This is you don't have them. Well, you do actually, you do have them. And the Boy Scouts and the Girl Guides are collections of young children, and there's an adult supervising them, and they do exciting things like learning how to tie knots, or how to light a fire using only one match, or chopping wood. They're taught how to chop wood, and they go hiking and camping and have a really exciting time. And they learn how to spot different types of birds and how to tell what tree is what, which one is an oak tree and which one is a birch tree. So the Boy Scouts, now there is a piece of legislation called the Protection of Names and Uniforms Act. So these uniform associations, the Boy Scouts is specifically for boys, but the girls have got their own. They're called the Girl Guides. They have baby ones as well, rainbows and brownies and Girl Guides and Rangers, and the boys have got the Beavers and the Cubs and the Boy Scouts and the Rangers. And the Rangers, when they get to the Ranger level, then it's a unisex thing. We get together and go camping together. You know the feeling. So you can't use the word Boy Scouts in your name or similar names because of the Protection of Your Names and Uniforms Act. But they're very few. These restrictions by statute are very few. The name will not be allowed if it's the same as an existing company or similar enough like Blake 7. And it may be disallowed as a tort. Now, I mentioned tort, was it yesterday? I think it was. A tort is a wrongful act or omission. I gave you examples of tort of things like defamation, nuisance, trespass, negligence, but also within that list that we briefly looked at yesterday, there was the tort of passing off. And passing off is using a similar name in a similar business such that confusion is likely to result in the minds of the public. Blake 7 would have been similar name, similar business, giving rise to confusion in the minds of the public. And it's not fair that if Eddie has a company and I create my own company called Eddie 2, then people are going to be confused. Is Eddie 2 in any way related to Eddie? And it's not a fair thing, because that means that I am then going to trade off the benefit of his goodwill. He's worked for years building up the goodwill of his company, and I'm now trading off that goodwill. I'm taking unfair advantage. So there is a case which is always mentioned whenever this question comes up. This is the case to mention. And it's the case Ewing and Buttercup Margarine. It's in your notes. And you can see straight away the confusion that is likely to result in the minds of the public. The names are so similar that everyone's going to be confused. Well, yeah, I can be a little bit naughty here and say, if you look at the name Ewing, in the word margarine you've got the E, and then you've got an upside down W, and then the I and the N and the G, so there's confusion in the minds of the public, but that would be naughty and silly. That's not what the cause of this problem was. Ewing had got an established company called Buttercup Dairy Products. Do you know buttercup? Do you know the word? Do you know what a buttercup is? What's buttercup in your language? It's a little flower. It's a little yellow flower. Not a daffodil. It's much smaller than a daffodil. You must have flowers over here. You have flowers in this country, don't you? Zjedi. It's a little yellow flower. You've got your dictionary. Oh, good man. It's a little yellow flower, and Ewing has formed this company called Buttercup Dairy Products, and it's trading. Buttercup Dairy Products trades in the southeast and southeast of Scotland and northeast of England. And Buttercup Margarine Company was a new company established. Is it not there?
Doesn't explain it. Small, bright yellow wildflower.
I thought it might be a translation dictionary. It's not a translation dictionary. All right. What have you got there, Benita? A small, bright yellow wildflower. Well, this is the work for this evening. Tell me tomorrow. I'm working. Okay, it doesn't matter. I mean, you know, Kelly is not going to say in the exam, describe what is meant by buttercup. All right, so just remember, it's a small, bright yellow wild flower. And as children, we pick buttercups and hold them under our chin or hold them under our friend's chin and say, oh, you like butter because it reflects yellow on your chin. But I mean, it's just a silly children's game. Piena? I thought that was milk. Oh, all right, fair enough. So you do the same, do you? All these yellow flowers under each. Why are we getting bogged down on this? Why are we worrying about the fact that when you hold buttercups and your hands go all yellow? Why are we doing this? We've got law to do. All right. Ewing and the Buttercup Margarine Company. Ewing had this Buttercup Dairy Products, southeast of Scotland, northeast of England. Buttercup Margarine were establishing themselves in the southeast of Scotland. Ewing said, no, your name is too similar. You're in a similar business of dairy products. There's likely to be confusion, and you're going to steal my goodwill. So he took it to court, and the court agreed with Ewing and said to Buttercup Margarine, change your name. There's one, and I'm guilty of digressing in a way which is not desperately relevant to you. There's one which confuses me dramatically, and it's about an English girl from London who emigrated to Australia, and she was a hairdresser. And she went to Australia and created her own company, and she called it British Airways, which I think is very clever. Who do you think came knocking on her door? British Airways. Now, tell me, I mean, you can see the similar name. All right. Similar business. When you go to the hairdresser, do you say, oh, while I'm here, can I buy a return ticket to Stockholm? Is that what you say? Or when you go to your national airline, you say, whilst I'm here, can you just give me a rinse and shampoo, please? There's no confusion. The only justification I can imagine why British Airways successfully prevented her from carrying on business is because I think British Airways is a registered trademark, and she was therefore in contravention or in conflict with a registered trademark. The same as you can't use a big yellow M. If you want to call yourself McDonuts, you can't put a big yellow M outside your premises because everyone associates the big yellow M with Ronald McDonald, don't they? So you can't do that. It's a registered trademark. And finally, on page 73, the word limited, or PLC, shall not appear anywhere except at the end of the name.